part of our presentation is in broader terms. We can talk about hypothetical situations. You all have questions, but it wouldn't be appropriate for me, for example, to start advising you on a particular contract fight you have right now and how to do it. You really need your own attorney for that. But with the understanding that the information here is broad enough that it could be applicable to several circumstances, and fundamentally some of the basic rights and obligations that people have coming into BART. Listed as a prime, a lot of the focus is on subcontractors. It's not just any subcontractors, it's subcontractors on BART's public works construction contracts. So the codes, the rights, the procedures we're going to be going into, all are focused on that kind of environment. BART also does contracting for buying things, procurements of equipment, material and supplies. There'll be a supplier, it's a purchase. We also have agreements for services, professional services, support services, that's an agreement. Those kinds of contracts and rights are not going to be discussed today. Focusing on construction mode, what happens there when you walk into that site, that kind of circumstance, and what are the pluses and minuses as you go forward. Our intent will be to be primarily focusing on the rights when the subcontractor doesn't get paid, some of the mechanics of that, and what options people have when you're finding yourselves in those kinds of circumstances. So I think right now, with regard to our presentation, you'll hear, as we talk about it, rights of a subcontractor. A lot of the points we're raising are equally applicable to a supplier to a prime. So if you were hypothetically providing the sheet metal for a job, you're not putting it in, you're just sending sheets with a pallet up there, and you're owed $10,000 for it, you're not paid. What do you do? And that's the kind of situation. You could be a supplier, you're not actually, then there's other people who are doing work on the side, the ones pouring the concrete, building the structure, and they don't get paid. What do they do? And sometimes there's reasons for that, sometimes there isn't, and we'll go over some of the steps one can take if you find yourself at BART with those circumstances. Just up front to understand, we're a public agency, so one of the key requirements that the state legislature in its wisdom for over 100 years has put down is that we have to go out with a sealed bid advertising process and award to the lowest price. So the prime contractor bids, you're the lowest one. You probably wonder what you forgot to put on your bid. But, you know, everybody else is higher, and you're like, okay, but that's it. The way it works with the legislature, since it's the public's money, they really are unforgiving. When someone bids and they say, I'll build that thing for you for $2 million, if you didn't estimate it right, you didn't realize you need an extra wall in the back, it's in the plans, we're going to say, hey, where's the wall? Within the $2 million, you can't get more money if it was always in the book. On the other hand, if we give you new changes, you may be owed more because of change. So those kinds of administration and job issues do come up and obviously will affect the sub. If you were the prime, but you hired him to do all the steel work and suddenly there's more than you planned on, you got to work issues out. BART might say, we always wanted 5 pieces of steel, and the execution is really in your hands. We're watching what goes on and trying to make sure it happens. As Harry said, our objective is to get everybody finish things on time, within budget, not to have anybody sink. But because it's the public tax dollars and they're unforgiving, our contracts are written not in a balanced way. They're biased, all in favor of BART. It's our money. We wrote it, so do it the BART way. We're going to bid with us. So it's not written for your favor for subs or necessarily even primes. There's other contract models, for example, the American Institute of Architects. They put out a model, one for the nation, and those are kind of even rights on both sides. We don't write them that way. Right? You got to do it the BART way. As you know, BART is a complicated technical system. We meet certain standards of construction, of systems, of materials. So we do it the BART way. And as a sub, you'll come into a contract that demands this, and you want to make sure you know your rights and you proceed with eyes wide open. So as we said, we cannot provide on our office legal advice outside. What our initial theme, or the initial topic, again, is issues with someone isn't paid. So our main theme to start with is the issue of stop payment notices. Under California law, it is not legal to put a lien on public property. Whereas if you were working on somebody's private building and they don't pay you, you put a lien on the building and you get your money out. A mechanic doesn't get paid, puts a lien on your car. With BART, you can't put a lien on BART property. So what the code say in the civil code is you can ask BART, if you were a sub and weren't paid, to stop the payment to the prime because you're owed money. So it really depends on your own status and whether truly you're owed it. And for us, the stop payment notice has to come in from a firm who's eligible to ask us to stop the payments to the prime. Keep in mind that process doesn't mean that we'll write a check to you because you filed that notice. It means we're not going to pay the prime the amount that's in dispute and a little bit above. And that usually, since money talks, when the prime's invoice isn't paid, go, oh, it's because George over here has a stop notice. You go, wait a minute, I want my money. Hopefully you work it out and it goes through. But initially, in order to be able to file a stop notice with BART, you have to fit certain prerequisites. So one of the key ones is the preliminary 20-day notice. So it literally means what it says. Preliminary at the beginning, when you're coming onto a job site on all one of the BART jobs, if you're not a first-tier subcontractor, you want to have this document filed within 20 days of starting work. What that gives you, it's a prerequisite. In order to be able to later file a stop payment notice when you actually aren't paid, you need to have had this on record within 20 days of doing the work. So the code reminds it. The idea is that, okay, if I did a contract with you, and I know you, I'm going to pay you, and I know you're first-year subs because they're listed, but then the first-year sub might be hiring somebody else, and I don't know that they're on my site. So the notice tells BART, look, there's another entity here doing work, and potentially they might need to ask you about getting paid. So that potential is really what you're putting in place. You're locking in your ability to later fight for your payments. The issue that we find, of course, when we're trying to implement it is that if it's not filed properly, then it might affect your ability to file a stop payment notice later. So the example we give here is that it only is applicable for any work done within 20 days of the filing of the notice. So this is the way we kind of illustrate that. You start work January 1st. You're working for 6 months. June 30th, you go, oh wait, I need to file my notice. So you file it on June 30th, and you're going to finish by October 20th. In our example, if you aren't paid for work on that job, you could only file a stop payment notice for work that was done within 20 days of the notice. So you file it June 30th, you go back 20 days, June 10th, any work done June 10th forward, you can charge against in that claim. But all the work you did January, February, March, you might have been buying material, doing stuff, you can't include in a stop payment because you took too long to file a 20-day notice. Yeah, I've had people, just happens, it's towards the end of the job, they're waiting to get paid, not paid. Well, you should have done it. Now they file a 20-day notice. When was the last time you worked? Oh, 3 months ago. It doesn't really help you legally. Now, from BART's end, I got to say, in practice, going practical things, this is the code, this is the law. But as it happens, as you'll see as we go forward, when someone files a stop payment notice, it's filed under penalty of perjury, which means it's a crime if you say something false. So we have a lot of confidence in BART. If someone's going to file something under penalty of perjury, it must be true because there's a burden on them if it's not. So we tend to honor those. So if you were to file a $100,000 stop payment notice, we would withhold $125,000 from the prime's payment. Always a margin above to cover extra costs. And then the prime suddenly, on their invoice, isn't getting paid $125,000. They're going to react. But that your claim that you're owed that money is signed under penalty of perjury. So if you said something that's not true, it could come back to you. We just assume what you're saying is true because you signed it with that certification. And if it's not signed, we might not honor it. So there are prerequisites to how the notice has to be filled out. I think as we go through it, you'll see the criteria, what's in it. So, and this one, this is a sample one. Just generally, it has the notice. This is a sample of the preliminary notice. So within 20 days, in this instance, the firm who filed it was, in this case, completed the American Asphalt Repair, contracted to PJ's Rebar for this job that was in BART's area near Oakland on the 4th Street, 7th Street, where we have facilities. I think it might be the Oakland Yard. So that tells us, look, this is who I'm working for. Here's what I did. I'm on your job. And it's duly noted. It goes into a file. We don't do anything because there's nothing to be. It's just giving us the notice. But it then puts the prerequisite you need for later in case this firm wasn't paid. So we go to the next slide. You'll see. So this is what is in a stop notice. The notice to us. We awarded the contract to the hypothetical. You're the prime contractor. We awarded to you, and the notice from one of their subs is telling us, hey, under penalty of perjury, the prime owes me money, whatever that. And you articulate a dollar value. You say, I did work at all the sheet metal, I did all the rebar, I did whatever you did, you describe it, and then we're obligated to withhold sufficient funds to pay that sub in case they don't resolve their issue. So we withhold the money. We don't give it to you. We also don't give it to the sub. We're just holding it. A portion of the progress payment to the contractor is stopped due to the notice. So if you did an invoice of $200,000, we do jobs that are millions, of course, so it easily could be that. But if you got a stop notice for $100,000, your invoice will be short $125,000 because of that notice. You'll be told about it, and then hopefully that'll motivate you to talk to your sub work it out so she can give us some relief and we can let the money out. And there's a few different options once that happens for the prime. So it's kind of good to understand as a sub, things could go a couple different courses. And if that should occur, you want to then reassess what your status is. Again, one of the things we said at the beginning, but I'll just say it again here now, it's really important as an individual, as an entity who has your own business needs and requirements to get your own particular legal advice when you're in some kind of fight. Let me step out of the slide just for a moment to talk about that part of it. It's actually really important to understand the role of an attorney. And I didn't know attorneys when I was growing up. I went to law school and stuff. But one of the things I understood once we go into practice is that you want an attorney who's totally dedicated just to your interest. So if someone's coming in needing an attorney, our practice would be everybody else would leave the room and there with that one person and say, look, I'm your attorney. We need to have open, candid discussions, but I'm only going to look out for your interest. So that the owner, BART might have something, the prime might have issues. That's not in the room. It's only what do you want? And we talk through it, hopefully with, since it's protected communications, you say everything that occurred, all the bells, all the blemishes, lay it all out. And then knowing that, I can give you the best advice for your strategy. So you did A, B, you didn't do D, but I don't think they'll catch you. You're telling me this, right? But I'm saying, okay, given where you are, the best that you can do is this. That step, the advice from your attorney, might help you as a business, keep you in business. It may end up leaving the prime hanging potentially. It may leave BART without something. But as your attorney, I'd say, what's the best thing for you as ABC sheet metal? That's my priority. That's what you want, an advocate just for you. And there's legal obligations to be a zealot advocate, as Charlie, who's in law school right now. You have to be an advocate for your client. Don't give it on there, you're championing them. Other people have their own attorneys. They should work out for them, you're looking out for you. And you want that so you can get the best situation for you long-term wise. And the assessment might be, just the reality is, you know better than I do. If a prime contractor hired you for a job and you wanted to get work with them because they did a lot of jobs, and he kind of pushes your envelope a little, do you spoil the waters by challenging him and he never hires you again? Or do you take it that time hoping he'll hire, there's business decisions to go on, but before you make your decision, if it's these kinds of issues, it is helpful to get someone to sit in the room and talk to you about your rights alone, because people have their own agendas. I did work with workers' compensation before, and the interest of the employer with regard to a worker who's hurt are very different than that worker's own person who's trying to look at what they need to make themselves whole. I might want, as a selfish employer, want them off my side because they're only going to be hurt again. But as a worker's advocate, hey, he has a right to hold this position. You can't discriminate them if they file a claim. There's rules on their side, and you want to hear that, just like in this kind of context. I just want to make sure you understand to go forward, even though it may be pricey, and we'll go into a little bit of it. There is a value to that you got to weigh in once the interests are strong enough. And lawyers practice different ways. Some will, for a small fee, have a consultation. You get your bearings. Some will do an initial step for a certain amount. And then others, they charge by the hour. Every hour they're there, the meter's running. And the people we hire for BART to represent us could be $400, $500, $600 an hour. It's not an easy thing to do. So I understand the difficulty financially, but if the stakes are high enough, sometimes you want to get at least some amount of consultation to help you out. So going on, so our practice, we would withhold 125% of the value of a stop notice. That extra margin is called for in codes, I think we were looking at. And it is supposed to cover any extra costs that come in case we have to fight about the stop payment notice. Once it's cleared, the money gets released back to the prime. So, okay, the next slide, this is what it has to contain. Civil code, these are the sections, they'll be in the material, but if you need to see what goes in it, we also have samples of them as exhibits, but it has to describe the work the sub did, the name of who one contracted with, who's claiming it, the verification, that's someone verifying that whatever was said above is true. That's the penalty of perjury thing. So you need verification. We ask in our contracts to give us the contract title and number so we'll know who to go to for the payments. BART has a lot of projects going on, and on many jobs, the same contractor has 2 or 3 different projects. So we need to know who to contact to implement the stop payment notice. So the notice should tell us, this is key, everything in our files is listed based on the contract number and title. It tells us which department has it, and even within that department, which staff person has it. In our Florida General Counsel, we'll know which attorney is assigned to it. So if you submit it, this is a big deal for us. Include it in there. It's really hard when something comes in and you don't know which job it applies to. It just varies. So this is a key part for us to be able to implement it. Now remember that it's really for what you weren't paid, not for other issues. As a practice, what I've understood, sometimes when people are trying, in your private situation, you're trying to negotiate with someone, and what's oftentimes advised in regular negotiations is that you may have a figure you want, but when you do your first demand, you do a little bit above it because you figure to negotiate down, maybe 30% or something. In our instance with these, you can't really do that. It has to be numbers that you say you in fact are owed. If you're overstated, it's false, there could be problems with that. So it's a different scenario, even though as a regular business practice, where we negotiate, oftentimes you come down 30% and you get the figure you really wanted, but you don't start there because they only come lower. That's with regular business negotiations. But I think in this formal context, you got to be more sensitive. Another element, which isn't in the slides, but I just mentioned because it is relevant, BART gets a lot of federal money. Federal Transit Administration, Department of Homeland Security, we get money from the state to carry on projects. And one of the state laws is the False Claims Act. So you can't submit something falsely for payment or else you could be subject to violating the False Claims Act. There's imprisonment, it's a crime. The federal, now that's submittals for payment. That's the state False Claims Act. The federal government, our federally funded contracts, within all the boilerplates of our big federal contracts, it has the Federal False Claims Act. And that has a liability if you submit anything that's false, not just submittals of payment. If you tell us you're ABC company and you're not really a minority business and it's a false submittal, that's a violation of that code, even though you didn't ask for money. State law gets triggered if you ask for money falsely. So when we have both of them, you got to just be careful with the submittals. Sometimes, BART, of course, our primary thing is to try to get the work done, the thing repaired, get the thing delivered. That's where we're trying to keep the system running. But because the grants are there, they're open to audits and the inspector general, and they can come in and look and then come back and pull back money that wasn't properly paid. So it's always hanging over there. BART is subject to audits. And honestly, what happens is that because it's public money, when you read in the paper, the public, it's their money, they're unforgiving. They're really unapologetic about hassling people when it looks like their money's being misspent. So with BART, we're a high-profile agency, and you'll get a material and Ross, well, look, they spent this and have nothing to show for it. It'll come across. And so there's always people watching it, not immediately or down the line. Audits could come up to 3 years after the job is done. So just be aware that it's constantly being watched. It's public money, and if it's not spent right, there's means by which they get it back. So it's always something that we try to get people to be straight about it, and just make sure that as you make submittals, they track your own records. You can back up what you're asking for. In this case, all these details will be in the stop payment. As once it's in, we'll withhold the money, and the burden would shift. Okay, so then the next slide here. There's a sample of stop payment notice. So it has us here. It says this is the contractor, Thompson Builders in this example. They work in Union City. The firm that gave some work was Satellite Painting. They were owed $37,429 out of a $129,000 contract, which presumably they've been paid some of the money they were paid $123, they're owed $161, so they want the balance in this notice. If this had come in, well, and then the verification is here, and then down below they indicate the date in which it's coming in. So all of this has to be in once we get this notice. Usually the way it comes into BART, it goes into either the BART district secretary or controller. They send it back to our department to make sure it's okay. Assuming it is, it'll eventually get reported to the project to hold up some amount on the next invoice. But this is the basic format. It's in the codes that we had there. So if you had to file one, you'd want someone to make sure you get to the latest version. In 2013, they changed the numbering of some of the civil codes. So you'd want the latest one. So if you happen to have one back in your files, make sure it's up to date just as things go. So then, so the process, it can be filed any time after a subcontractor is not paid. So you did the work, you weren't paid, you sent an invoice not paid, you could file a stop payment notice. But the last time to file, the latest period you have, the final chance, is after we file the notice of acceptance. So under the civil code, once a job is completed, BART regularly files what's called a notice of acceptance with the county recorder. Under the civil code, once that's in, the clock starts running. 30 days later is the last day to file a stop payment notice. So if you didn't, they kept promising they're going to pay you, you realize it's the end of the job, you still haven't been paid, you better get one in before the 30 days are up or you'll lose that as one of the remedies. So it's important to be aware of when it happens. And as you all know, delays happen on projects. You thought you were going to finish in 6 months. It's been pushed out. So you may not know when the acceptance is. You might have hypothetically done work early in the job. You're clearing the site. You set the foundation. It's like 9 months later. You're at another job. Now they got the rest of the building and the roof is up. And you're still waiting for your money for the initial foundation, let's say. But you want the last chance to do this notice is 30 days after acceptance. How do you know when it occurred? So this is how you do it. So if what you want to do is request a copy of the notice of acceptance once it's recorded by sending a $10 check to our district secretary. Now, once you do that, we have a legal obligation to send you a copy of that once it finally gets to the county recorder. So when they have that check, and district secretary is always the one that does, they go down to the Alameda County Courthouse, do the recorded notice of acceptance. When the stamp comes back, they'll make copies, and whoever had this check are all sent the copy. Now you know once you get that, the clock is running. The notice will say this was recorded as of April 10th, so you know by May 10th the time is up. And if you don't get this, you could really be out of luck. So this is an easy way to get something else under your belt. And the thing is, it's helpful just to go ahead and ask for this, put it in early. One things I find is that when people are getting along, everything's on verbal, we're getting along good. You know, I need this extra slab pour it, I'll make good. Can you go ahead and pour it? You don't get a change order. It's $80,000 worth of work. You paid it, you're waiting, and what do you mean $80,000? I only did the front steps. What about the back one? And you go, well, that. Isn't that only 15? No, it was 80. You know, you're arguing. But if you didn't do this, you don't know. Time could go lapse, and by the time you try to push it, you're out. We have one firm, just stories again. I do a lot of this. Last year, they did sheet metal work, one of our projects, and they had a big fight about the sheet metal. We had a problem. The sheet metal didn't match the finish that the rest of the station. We needed it replaced. The sub was saying, hey, I was hired for this sheet metal. I'm owed the money. BART said, that's not what we wanted, to the prime. And the sub is saying, well, that might be what BART doesn't want, but between me and my prime, it met my subcontractor. That was the fight, big fight. We keep going forward. Another firm has similar kind of payment issues. They file a stop payment notice suit within the time after recorded notice of acceptance, which in that job was done in September, 90 days. That's what we're talking about here. That's a deadline. The firm with the sheet metal, who we had all kinds of meetings and mediation with earlier in the year, forgot to do this. So I get a call in December from their attorney saying, the prime tells me I'm out of luck. Can you tell me, is that true? You know, I'm not their lawyer, so I had to be careful. This is why we do things upstairs. They said, here's a copy of the notice of acceptance. I had to be very non-committal. It shows that it was filed on X date. Based on a civil code, the time to file suit expired on Y date. So I believe if you review it, you may not be able to. I didn't want to tell them you're out of luck. I mean, but the code was the code. The prime knew this. They had their lawyer looking at it, and they said, hey, the deadline passed September. We're free and clear on the stop notice suit. They would still be able, as we'll talk about later, have other remedies, but this remedy kind of disappears. And because, as we'll talk about it later, since to file this notice, it doesn't require asking for the check or even a stop payment notice, you know, a lot of time with a pricey attorney. It's a way of pushing your rights without spending a lot of money. And it's a good tool. It doesn't necessarily get you the money in hand, but it gets the people talking and might get you your money. And we'll talk through what would happen next. So the process is once it's filed, we withhold 125%, and the withhold only applies to the next progress payment that is due after we receive it. So the way our payment process works, once we get an acceptable invoice in our process with our system, it's submitted electronically at BART these days, then a 30-day clock starts running for us to issue a check to the prime. And if within those 30 days, a sub gives us a stop payment notice, then it only applies to the next one. This check is already in the system. So we try just be straightforward. It applies to the next progress payment. So that's just the mechanics of how we do it. So once it's filed, the burden check, I'm going to keep looking at you, you don't mind, you're prime, right? So once that happens, here's the other side, what the prime can do. So you're a sub, you file a penalty of perjury, hypothetically you're owed $100,000 for all kinds of work you did on the job. And you weren't paid that, you were paid maybe $95,000, you still owe the other 100, whatever, like that notice. So the prime can agree to pay the amount. They say, you're right, I owe it to you, here's the check, and then you get a release. It's a document that says, I hereby release the stop payment. That's one choice. Another one, the prime can say, they're full of hogwash, I don't owe them anything. There's a kind of bond called a stop payment notice bond. And a prime can take one of those bonds out. It has to be in 125% of the size of the stop notice. If we get that bond, we'll go ahead and release the money to the prime. Now to buy that bond, you have to pay a fee to the bonding company. And one would do that if the prime is convinced that it really doesn't owe the sub that money. Because just keep in mind, surety companies don't like to pay out. They like to collect like insurance companies. They'll take your premium. They don't have to pay on a claim. So the primary person responding to the contractual obligation is the prime. They hired the sub. They owe them the money. The bonding company is there as a backup. And in this example, The reason this bond came in is because the prime wants that cash release. So in my example, I'm withholding $125,000 of your money. You need that money. You're willing to pay, I forget the fee, it might be 3% of a bond for $125,000 to be able to get that much. So you might be out $3,000, $4,000, but you got a $125,000 check from BART. And it might be worth your time. So that's one way to get the money released. Otherwise, you're holding on to it to the bitter end. The other way, this is a whole different document, is an affidavit. So an affidavit, he said, remember, we were talking at the beginning, when it's filed, it's under penalty of perjury. So essentially, an affidavit is a counterstatement from the prime saying, I object. I swear on an affidavit that I do not owe her that money. I am fine. Yes, you should not hold on to that money. Give me my money. So if we get an affidavit, again, signed, we'll honor it. We're going to release the money, but we'll tell, I'm picking on you. If you were the sub, I would say, as they file an affidavit, we're going to release the money unless you give us a counter affidavit. You say, au contraire, mon frère. He's wrong. I'm right. I counter his affidavit, hold on to them. So then we go back to holding the money. So you see it going out, coming back, going out, coming back. Once you get this last step, then that stops the process. We're holding the money. The only way to get the money to move after that is to file a stop notice suit. So the money's, you're not getting the check. We're holding on to it the whole time because the counter affidavit came in from the sub. They're insisting we hold the money. They disagree with your objections. And so it just sits there to the end of the job or until a lawsuit is filed to ask a judge to tell us who to give the money to. Again, the facts regarding that fight, whether the sub really did do that much extra work, whether your subcontract really did provide for extra payments or the underlying merits, they're not BART's arguments. We're kind of mechanical there. He told us a dollar value, we're holding that. Whether you were right or wrong is not our fight. And we advise our clients to stay out of the fights between the prime and the sub as much as possible because BART only has a contract with the prime contractor. Now, having said that, I need to do deference to our Office of Civil Rights. They are here to try to help firms when people run into trouble. The way our construction contracts are structured, we have a role in the contracts for an ombudsperson. So this is someone who's there as an advocate for subcontractors of all levels to look out when they have payment issues. It's different than the support services who are general, and like this session here where I'm talking general terms. But if you have a specific fight as a sub and aren't paid, you go to Office of Civil Rights, they can, through using the ombudsperson, have someone investigate and review those issues down the tiers and come up with some idea of how to solve the problem. It doesn't change our contract stays unchanged. I'm really adamant that there's no legal alteration to the corners of what was signed with the prime, even though an ombudsperson finding a subcontractor who has some issues and they really are owed more money for some reason. Many times, just to understand the dynamic, it's not that BART owes the sub more money, it's that there's been a change in what the prime asked the subcontractor to do. And it just happens, the nature of the beast. You're there, you're signed on to do 3 entrances of concrete, you got the labor, material, equipment to do it, you're mobilized, and then the prime says, oh, you know what? I was supposed to do the foundations for the light fixtures in the parking lot in the back. Can you put all the cylinder things? I'll put the poles. And so you have to mobilize now in the parking lot. Was it in your subcontract? You do, 45 different, beam columns for the light fixtures all in this parking lot. You're owed, I don't know, $85,000, whatever. You did it as a favor. He promised he'd pay you. And you keep going, your job is paid for, you did extra work. As far as BART's concerned in its contract, it always wanted 45 light fixtures. It's not a change order for us. We are not going to pay the prime more money because it was always part of the original bid. But the prime came in thinking they were going to do A, B, C, and D, and you were going to do E. Then he finally gave you a little bit of D. In that scenario, this is why it's kind of a sensitive point that when we talk about what it is that is being said or not said, BART isn't getting into the mix. If I were your attorney, I'd sit there and tell you, here, you got to fight for this. You have every right to demand A, B, like my hypothetical about the extra work. Here's the letter he sent you. Here's the invoice of what you did. Put it together. You push something to advance your issue. But when BART is looking at these and that fight's going on, we're outside of it. So we really rely on good faith on what's said and just honor what's there and ideally not get into the mix of it, except, as I said in my example with the ombudsperson, it's an exception, but it doesn't alter these procedures. Our Treasury Department won't do anything different because the Office of Civil Rights has an ombudsperson investigating somebody's problems down the tier. The payment still follows the book, and it's very, very tight. So if you file a counter affidavit, you stir out hypothetically $100,000, your next remedy is to go into court. So you'd have to file a stop payment notice suit to enforce the stop payment notice. Essentially prove to a judge that you truly are owed that money. So what comes into evidence is your subcontract, pictures of working in the field, invoices, whatever would prove your case. So in that scenario, for example, you might show your bid to the prime. Here's the bid. My price, as you can tell, had A, B, and C. I never had D in it. My price would only be B and C. Here's the notice where you told me to put the extra concrete. And here's my invoices, my labor, materials, equipment to get out to remobilize in the back. I was already done with the pour. I had to come back again. That's an expense to mobilize, as you all know. Whereas if they gave it to you early and your crew's already there, pouring a little extra concrete may not be as expensive. But in my example, this is a big extra cost. It was a big favor. They were able to meet the deadline of the job for the prime because of your work, and now he's not paying you. So, you know, the lawsuit then takes into court. You have to prove your case. It's full litigation. And it's whatever you said in your original stop notice should be the same story throughout. You shouldn't start out saying one thing, and by the time you get to here, your story's different. I used to do general practice before coming to BART and preparing cases when people had problems. One of the things we oftentimes recommended, if you had an issue, to keep a separate file about that matter and document what was going on. Keep a log of what occurred. So if you speak on a Monday, keep a note on the folder that's there. Monday, September 10th, we talked about the problem with the light fixtures. You know, September 15th, George asked me to go ahead and pour the concrete. 16th, he got the drawings. 17th, I got my invoices to give him an estimate. You document what went on there. October 1st, we agreed to go ahead with it. I did, you know, your pictures. So you keep a record. And later, when you have the fight, if a judge is looking and he goes, no, this is truly what happened, and you've kept like a chronological log, it's very persuasive from a judge to show, look, I didn't just write this and fill in a gap. Really, on May 10th, because after I wrote what happened on May 15th, in sequence, it shows like it's a straightforward chronology of what occurred, kept contemporaneous with when it happened is even stronger. What isn't as convincing is that, let's say, you're arguing now in September, they argue something, and you all of a sudden create a memo that was written that evening about what occurred 6 months before. You're like covering yourself. It doesn't look as persuasive. Whereas you wrote the memo in your notes 6 months ago, right when it occurred, and now you're arguing a few months later, no, that's exactly what happened then. And see, I wrote this after, so it's more convincing, it's more, I think, persuasive for a judge to see it your way. So if you do end up with a matter, it's really not a good practice to rely just on your memory, rely on verbal things. It's really, we were talking about earlier, some of our offers going to small claims court. The small claims court judges rely a lot on evidence. If people are just saying stuff, they hear stuff, it's hard to go your way. You show them pictures, you show the contract, all consistent story. Consistency is key. So if you're writing a letter to someone because of your demands, make sure your demands are consistent in the first month versus second versus third. So if you start changing your stories, it sounds like you're just fishy. It doesn't look as consistent. So a consistent story is key in terms of your own record keeping as you are looking to pursue this kind of issue. Now, if you do file suit, you should, among other things, name the stop payment notice bond surety that was used to release, in my example, the $100,000. And it's because then they essentially guarantee that if you were that sub, you'll get paid if the prime doesn't pay you and you win in your lawsuit. So if they're not named in the suit, you lose another source for the money. Sometimes, unfortunately, what happens is that companies go under. Well, where do you go to get paid now? You're still out $100,000. This is where you would go, the bond notice, if they filed one. So you do have a place to go to.
$100,000 plus all the legal costs to try and collect.
Yeah, you would call for that. You know, say you did everything right, they did everything wrong. Now the stop payment notice bond surety is standing in the same shoes as the prime. So hypothetically, if your bid did include A, B, C, and D, and you didn't do D, that's why they're not paying you the last part, then the surety company will have the same argument that the prime did. I'm not paying you that because you didn't do that extra piece. Yeah, but I meant to. Oh yeah, but surety company will be just as strong and maybe even more strong in trying to keep from having to pay you anything. So they'll use every argument the prime had. They have all those rights. It's called subrogation. So essentially stepping into the shoes of the prime, all the rights they had in their contract they can use to defend themselves against that liability. The prime already paid the fee for the bond, and as exchange for paying that fee, they agree to defend it if it gets to that. But if they're liable and they end up having to pay them, they'll go back after the prime and say, hey, you owe us for this guarantee that we had to pay out. All right, so you go to the next one. So this is at the tail end of the job. Remember, we talked about getting the copy of the notice of acceptance. So here's the deadlines that go with it. Within 30 days after filing recording the notice of acceptance, the contractor is supposed to, with BART, submit a proposed final invoice This is under a normal construction contract. Give us an invoice that says all the amounts to be paid, including whatever we had as retention, and then any amounts in that invoice that are related to stop payment notices. So if you didn't file a bond to get rid of them, we're still holding $100,000. It was a $10 million job. A few outstanding issues. One of them is Charlie's stop payment notice for $100,000. So that last invoice will say, well, you're still holding $100,000 because of so-and-so, and $50,000 because of somebody else, along with any claims. So that's what we get. BART uses that to prepare the final payment. So have hypothetically the job was $10 million. We've paid out so much, 8 point something million. There's 1 point something left at the end with retention and everything else and these issues. And the prime is asking us, write me a check for this amount. That's my bottom line. BART looks at the proposed final invoice and reviews to make sure it's accurate. And if it is, then we'll get prepared the final invoice for payment to write a check on. That check will not include any values for any of the stop payment notices that are outstanding, nor for any claims that are still unresolved. Potentially, if there were liquidated damages, we would withhold that also. And then whatever's left would be the check to the prime at the end. So unless a release of the stop payment notice is filed, or we get the stop payment bond like we described, we will continue to withhold 125% of the value of any unresolved stop payment notices from the final payment for 90 days after the acceptance is recorded. So this is another deadline, because once the money goes out, you can't sue for us to put it somewhere else. But within that period, you can file a lawsuit to say to a judge, have BART give me the money that it's holding instead of holding it for the prime. You just got to do that within 90 days of the recording. Another reason to put that $10 check and get a copy of it. So if no lawsuit is filed within 90 days after the recording, then we'll just give the prime back the money. There's no legal right for us to keep holding it any further. So there are very strict statutes of limitations, as we're pointing out here, to enforce your rights. And at the very end, you have one last chance after we record the notice of acceptance to try to assert your rights. And if you miss that, then you're left with other kinds of remedies. But this one goes away. So we go to the next slide. So releases, this is a statement from the sub who filed the claim that they've been paid. They're okay, it's okay for us to let the money go. There are specific release forms in the civil code, section 8126, 3238. If they give you part of the money, you may do a partial release. If they promise to give you the money, you agreed on the amount, you were arguing for 100,000, they tell you, look, if I give you 85, will you be okay? You go, yes. So you might agree conditionally to release your $100,000 claim for $85,000 just to get a check. So you sign a release conditioned on getting payment. So conditional means you haven't actually been paid, but you agreed on the terms. For BART's end, a conditional release means that I got my check, I have no reason to hold it anymore, I'm releasing it unconditionally. This form under the civil code includes like a bold all-caps statement that says, don't sign this unless you've been paid, you're giving up all your rights. And the code mandates it because, I mean, lawyers can read all the fine print, but regular people read what you see. And someone might be wanting the payment and not, I'll sign anything, just give me the money. Then they changed the civil code because it was a little too burdensome. They said, as long as they describe clearly, accurately, they're releasing the money, we should be willing to accept it. So it's now gotten more open-ended. And we get simple letters saying, I hereby release it. If it says the value and it matches the people, we'll honor it. Because the code now said we had to. I used to be real strict with this and hold it up, but no longer. But these will give you a form. And these each give you language. It has a blank, so I am so-and-so and I'm releasing blank. So why might you agree to release the funds? So the first scenario is that you and the contractor have resolved the dispute between each other and have determined that no further action is needed. You got your money, you're good to go, so the release comes in. So you say, the other one, scenario 2, the prime contractor has promised to pay you the disputed amount, but they need the funds from BART to pay you, so it's a conditional one. If we get a conditional one, we would only release the funds after proof of payment is submitted, which essentially is a canceled check cashed by the sub. So proof they actually got the money. A conditional one says, I will release it if I get the money. Well, once you get it, then we'll let the money go to the prime. So this last one, we end up needing the canceled check, and that sometimes could take a bit to get from the bank and stuff. But it is the other way. This is why I think it's preferable, of course, to get an unconditional one, because that just lets the money go right away with that in hand. So the next one, okay. So a partial release is what it sounds like. You've been paid part of the money you owed. So the hypothetical 100,000 one, the prime pays you 50,000 now. So you tell BART, okay, you can release 50,000. So initially, which was 125,000, now it's what 6250, I guess. 62,000. So he just reduced it like that, 62,500. And we continue to withhold the remaining balance of whatever wasn't yet released. So let me go into this now with Charlie Trevino here.
So the first one, as Ramiro alluded to earlier, is the stop payment notice bond. This is part of the civil code, as you can see there. The bond must be equal to 125% of the value of your stop payment notice. Interestingly, they have to obtain the bond from a different surety insurer. And you can go to the next one. And the reason why a prime contractor would do this is because if they want to obtain the funds before they resolve your stop payment notice, that's how they can do so. But they are required to receive a stop payment notice bond. BART is also required to give you notice that they have released the funds to the prime contractor because they have obtained a stop payment notice bond. And in terms of your legal remedies and your standing, not much has changed because they, as Ramiro has said, they have basically assumed the position of the prime contractor. And in the event that you do sue, you should name the surety and the prime contractor and everybody under the sun, typically. You can go to the next one. So this is just a visual representation when you reference back later. As you can see, every prime contractor, when they are in a construction contract, they have to have a contract payment bond for 100% of the value of the contract, 100% of the value of the contract. Yeah, which Daniel will describe further. And so in the event that you're the subcontractor, you're working for the prime contractor, you file a stop payment notice with BART. Okay, they withhold a certain portion of the funds due under the contract. Go to the next one. So then the prime contractor, they get a stop payment notice bond. Okay, so BART releases the rest of the funds. And this is a separate bond from the contract payment bond, which you may also file suit against. But this is important because this is just for the value of your stop payment notice claim. So nobody else other than you will have claims on this bond. So there may be other subcontractors filing claims against the contract payment bond. There may be other liabilities related to that. This is only the value of your claim. You're the only one that will be filing claim on this. You will not be second in line in front of anybody. And now I'll go to Daniel for contract payment bonds.
So the other kind of bond that comes in play here is a general bond, payments bond, also known as a labor materials bond. This is separate from the stop notice payment process. This is a bond that contractors have to obtain as part of their initial bid. If the contractor does not have the payment bond as part of their bid to BART, BART cannot award the contract to the contractor. So this is there from the beginning, and its sole purpose is to provide a remedy for subcontractors and suppliers to provide, if they don't provided to guarantee payments to them. And so, as we said, so subcontractors have a right to file a claim against the payment bond for any amounts the contractor fails to pay under the terms of the subcontract. So if subcontractors file a stop payment notice suit, they should also name the payment bond surety as someone else that can guarantee payment in the event of a win. And subcontractors may request a copy of the contractor's payment bond from BART's district secretary, similar to how you can request a copy of notice of acceptance. So this is an example of a payment bond. 2 points to highlight, so there's a lot of legalese, is that's the bond number up there that you should sort of note in your filing of a claim. And down here is, it's a little blurry, the name of the surety. And that's the company, the entity that would be actually paying a subcontractor in the event that they file a claim and win the claim. And they also submit a second page that isn't up here that contains more detailed information about how to contact them in the event of filing a claim. And I believe that's, yes.
Sure.